seat, please.
Just been left alone. Apparently it's a slow roll. All right, we've got, so you ready to go?
Yes, Judge.
All right, we've got the defendants present, represented by counsel. We've got the witness back on the stand. Let's go ahead and get the panel.
Objection, Ms. Burton can come in when she's ready.
That's previously, that's fine.
All right for the jury. Please be seated.
All right, welcome back, ladies and gentlemen. State ready to proceed
Yes, Judge.
from the state.
Thank you. So, Dr. Donoghue, during the autopsy, what personal items were found in Mr. Arbery's clothing, if any?
No personal items were found. No phone, no wallet, no weapons,
Nothing?
nothing.
And the projectiles that we've already talked about that were in State's Exhibits 342 and 343, they were sent internally within the Georgia Bureau of Investigation,
Right.
but to,
We haven't talked about all of the projectiles.
all right, let's go ahead and talk about all the projectiles.
Well, we found something that looked like black plastic fibers in the wound to the chest and axilla or armpit. And these were sent to the crime lab for identification, and it turned out to be botanical material, meaning some sort of plant. That's just another thing. That's a very unusual thing to remove from a shotgun wound. And
All right, so let's talk about this. When you first were examining his body, this stuff that turned out to be botanical material, where was it?
well, it was within the wound.
The one up here in the
In
left
the,
armpit?
Yes.
Like how far up in the left armpit?
Well, I don't remember exactly, but it was not on the surface.
Okay, not on the surface. All right. In addition, when you first described it, what did you think it was?
I thought it was black plastic fibers because I could only presume that it came from a shotgun shell, and usually the things in the shotgun shell are either lead or plastic.
So you sent it off to the trace section,
Yes,
but they determined it was botanical material.
yes.
Do you have any opinion about how botanical material would have gotten up into the wound track on Mr. Arbery underneath his left armpit.
And it was black, so it leads me to believe that it somehow had gotten into the barrel of the shotgun, possibly why they were struggling, and maybe pointed it down into the ground and came up with this botanical material.
So we've talked about the botanical material and the pellets that we are looking at in those two exhibits sent off to Bryan Leopard.
That's correct.
Now, here's the thing. Once Mr. Arbery had been shot in the torso right here, how in the world did he keep moving?
Well, this is what is called the flight or fight reaction, and when you run into a situation that is stressful or that you're afraid of, or is going to cause anxiety, your body will the amygdala in the brain will correlate a flight or fight response. So it stimulates the adrenal glands to secrete adrenaline and noradrenaline and cortisol. And this has the effect of raising your heart rate, raising your blood pressure, dilating your pupils, even your acuity for hearing improves. It also shuts down the blood supply to the bowel or the gut, so that more blood can go to the muscles. And this prepares you either to run or to fight.
Okay. So, if Mr. Arbery had been under a very stressful situation for 5 minutes, okay, and we're talking fight or flight takes place, has he already got that adrenaline going in his system at that point?
He would, as soon as he realized that there was a threatening situation, that response would start.
Okay. And flight, meaning I gotta run away.
Right.
Okay. What happens when you can't run away anymore?
Well,
I'm going to object. Beyond this witness's expertise, the area in which he's been qualified, and it's asking for speculation.
Lay foundation, it's sustained unless there's a foundation.
Do you have the expertise to address that particular issue of why someone who can no longer flee or run away would turn and fight?
well, it's
Objection, that was not his testimony, Your Honor. His testimony was after the first shot, what would have allowed his body to continue to move. What Ms. Donoghue is now asking about is whether or not how he reacted before the first shot, and that's not a proper area for inquiry with this witness.
I'd sustain the objection asking for a foundation. I understand you were trying to lay a foundation.
That's what I was trying to
Depends
do.
on the foundation. See what his expertise and knowledge is.
And that's what I'm just gonna ask. Doctor, do you have the expertise and knowledge based on all your years as a medical examiner, forensic pathologist, to address fight or flight responses?
well, it's the fight or flight response. So after you could no longer flee, you might fight.
Now, anatomically, when we're talking about having been shot right here in the torso, okay, did those pellets hit his or pierce his heart at all?
They did not pierce his heart.
Okay, so the heart's still beating.
The heart's still beating.
What did they pierce within his torso?
Well, they got the fifth right, the anterior, well, first of all, they got the lower portion of the sternum, the breastbone. They've got the anterior fifth right rib, the fifth right intercostal space, that's the space between the fifth and sixth ribs. It got the anterior sixth right rib. It got the right middle lobe of the lung, the right lower lobe of the lung, and then it got the lateral 6th through 10th right ribs and the corresponding 6th through 9th intercostal spaces.
So did it break ribs 5 through 10?
Yes.
All right, so all the ribs over here got broken, 5 through 10.
Yeah. Yes.
What happens when you break all of these ribs over on the right lateral side?
Well, it becomes difficult and painful to breathe. And also, there is the intercostal arteries run on the lower edge of those ribs, so you would bleed into the chest cavity.
All right, so when we see Mr. Arbery with all the blood underneath him at the crime scene, was that due to that blood into the basically chest cavity?
Yes.
All right. So the gunshot wound to this torso, was that a fatal gunshot wound? If he had never gotten this one under the arm, would that one in the middle of his torso have killed him?
Yes.
Was there anything EMS or the officers could have done on the scene to save his life from the torso shot?
Well, they could put an occlusive dressing on the large defect, but you would still have the exit defects in the back of the chest. And they couldn't do anything about the bleeding as long as the heart was beating.
So would he have just, in other words, is there anything they could have done on scene to save his life?
No.
And then I think lastly we have State's Exhibit 413. So I'm going to show you what's been marked as State's Exhibit 413. I'm just going to show you the exterior of the bag. Prior to coming in here today, were you able to examine all of the items collected from Mr. Arbery, including his clothing and the shoes?
Yes, I was.
All right, and is what's contained in State's 413 the shoes that you collected from Mr. Arbery?
Yes.
At this time, the state would tender into evidence State's 413.
No objection.
Judge, I object on relevance grounds. What's the relevance of these tennis shoes?
The relevance of these tennis shoes is to demonstrate that he wasn't.
Objection, Your Honor, if this is going to be a speaking response to this objection, we would ask that it be done outside the presence of the jury. This is an issue the court has been very clear about.
Okay, ladies and gentlemen, if you could just step into the jury room for just a moment.
All right for the jury. Please seated.
Ms. Donoghue.
Your Honor, the state does not wish to put in a large amount of his clothing due to the contamination situation. So we're not going to put in the belt and the pants and the t-shirt or anything like that. They have photos of those items. The shoes in the state's opinion are relevant because the state's argument is going to be simple, that Mr. Arbery, based on the evidence, when he would visit 220 Satilla Drive for a few moments and go in, would take off running into the neighborhood. That's the evidence. So this, of course, shows that that particular day he had running shoes on. This was what he was wearing. He walked up to the residence and then he ran away. And these are just the shoes that he was wearing. So it's evidence of what he had on that particular day, his running shoes.
It's a backdoor way of entering into evidence what the court has already ruled so far the state can't do, which is to argue that Mr. Arbery is a jogger in the neighborhood. There is no relevance of the shoes in and of themselves. It didn't inform this doctor of anything he had to do in performing his autopsy. If the state wants to argue that Mr. Arbery is a jogger based on the fact that he's wearing tennis shoes, then we should have the right to provide, again, that alternative explanation for why he's running.
I join in with Mr. Rubin's objection for all of those reasons and reiterate now for the third time, the shoes and their condition and the type of shoes they are is just another way of saying to the jury, look how much he runs. He runs all the time. Therefore, that's what he was doing on 2/23/20 when they encountered him in Satilla Shores. If that's the relevance of the shoes, the state hasn't said it quite that way, but that's the only relevance of them it could be. It opens the door to us to say, well, then let's give you some alternative views for why he would be running in Satilla Shores on 2/23/20, what we had an argument about the other day and the court made a ruling. This isn't the same type of evidence the state's trying to introduce now.
Based on the state's explanation of why they're tendering this exhibit, we will join in the objection of the McMichael defendants. I'm very concerned about these shoes going out to the jury. My understanding these are in fact Max Air Nikes. Most but not all of these brand of running shoes, these athletic shoes, are running shoes. Some of those branded shoes are shoes for other events, such as basketball. Now we're going to be sending back these shoes without any expert testimony or other testimony establishing what kind of shoe they are for the uninformed and unguided speculation of the jury as to whether these are in fact running shoes or not. There's been no testimony, and unless there's something in the discovery I didn't see, there's been nothing presented as to the tread or the composition of these shoes to establish that they're running shoes. We're just going to send them back to the jury and ask them to speculate about it. That's highly improper. And I agree with the McMichaels. It's going to open the door to all kinds of testimony that I thought the state didn't want to get into. I object at this point to the tender of these shoes.
I won't tender the shoes. That's fine.
Okay. If I understand, the tender's withdrawn.
Hmm?
The tender's withdrawn then?
Yeah, I'll withdraw it. That's fine, Your Honor.
All right, squeak, now.
Yeah, can we inquire, though, whether the photograph of the shoes that was used in the opening statement, and apparently has been introduced somewhere along the way here, hasn't already done the same thing the actual shoes have done, so that the state will now think, well, we can go ahead and argue in closing argument by showing the photo of the shoes, what they argued in an opening statement, and that is he's an avid jogger. Again, we don't dispute that he was an avid jogger. We just dispute whether we can now offer an alternative explanation for his running on a particular day and place. So if withdrawing them now still leaves the state open to making that argument in closing, if they're indicating that's what they plan to do, then the door's open. And we should be allowed to give alternate explanations for his running on 2/23/20.
As I understand it, the state has withdrawn the tender of these shoes, so that's not an issue. As far as opening the door, whatever evidence is in, and as far as the court is concerned, that door has not been opened. So let's go ahead and get the panel.
Yeah, if I may just to clarify then, if we don't know whether that's the argument in closing until they get to the closing and the evidence has been closed, then we've lost our opportunity to provide an alternate explanation for what I anticipate will be an argument by the state to the jury.
No, the door has not been opened. If that's an argument that's made simply based on a pair of shoes that Mr. Arbery was wearing, that's what he was wearing at the time in the neighborhood. But there's other evidence that can be argued. So no, it has not opened the door to matters that have not come into this point.
May I inquire though, Your Honor, because I'm really trying to follow with you and perfect the record, not arguing with the court. The shoes, though, are of particular evidentiary concern to the state and obviously therefore to the defense. His belt is of no concern. His shorts are of no concern. The shirt's value is minimal. It just shows where he was shot. His underwear is of no concern. The shoes, though, are critical, as I see it, to the state's argument that they've set up from opening statement forward. So I'm not sure what the court's saying. Other evidence that has been introduced has to do with the evidentiary value of the shoes. And of course, the shoes themselves now are being withdrawn, but the photos in, the argument's been laid. I think the door's been open already. That's our position, Your Honor.
I don't know, the court has specifically said, based on what I understand of the evidence at this point, the door has not been opened.
A related point, Your Honor. Under Georgia law, the state has the opportunity to open and close. In this part of the state, prosecutors typically waive the opening portion. I think Ms. Donoghue has indicated that she's not going to waive the opening portion. My concern is the court has discretion over closing arguments, and I would ask the court to require the state, if they're going to address this running shoe argument in their closing, that they do it in the first half or first portion of their closing, so that defense counsel can hear the state's argument for the first time before we have to respond. Otherwise, the state's going to come in after everybody's rested and throw this argument out there, and we're not going to have any options other than to try and object to it. And it's a notice issue, not just a fairness issue. Not just whether it's based on the evidence, it's a due process fairness issue for the state to come in after all the defendants already rested in the trial and put forth some novel argument, some clever argument based on these photographs with respect to these running shoes. The court has the discretion to require that argument, if it's going to be made prior to defense counsel having to give their closing statements, unless the court's planning to allow us to reopen and re-argue the case after the state is done.
Why don't we reach this at some point that's more relevant to where we are in the trial? I'd like to get the jury back in to finish this witness's testimony. The state has withdrawn its tender. If you want to raise that matter later, you're welcome to do so, and we can address that. Let's go get the panel.
All right for the jury. Please be seated.
Welcome back, ladies and gentlemen. I understand the state is withdrawing your tender.
Yes, sir.
All right. From the state.
Dr. Donoghue, what was Ahmaud Arbery's cause of death?
It's my opinion that Ahmaud Arbery died of multiple shotgun wounds.
I'll pass the witness.